So how it's going to work today, we're going to run a little Q&A between myself and Sue. Sue's going to answer from a mediator's perspective and I'll be answering from a solicitor's perspective. So it's all about mediation and to give you a further insight and hopefully answer any questions that you do have as well. We're going to take a break in between just for you all to grab a tea or coffee. And during that time and throughout the call, we'd encourage you to use the chat function just to ask any questions that you do have. And Sue and I will be aiming to answer those in the middle of the Q&A and at the end of the session as well. So Richard from EMG will be managing the chat function throughout our coffee morning. So like we said, we do invite you to ask any questions, and this is an open discussion, so feel free to ask any questions that you do have. Okay, so over to Sue.
Hi everybody, welcome and thank you for coming along. I'd like to thank Sophie for asking me to join her today, and also, as I say, for coming along as well, as I do appreciate that, you know, we do all have busy lives, and it is really appreciated by both of us that you've taken your time out to come along and listen to what we've got to say. We are intending on recording the session for a possible future podcast or for some different social media use. So please do keep your video and microphone off unless you wish to be recorded. And it also gives you the added benefit that you can pop in and out if you're at home and nobody will know. So for those who don't know me, I work at EMG Solicitors, both as a family lawyer and as a mediator. And I've worked in family law for about 30 years, which either makes me very old or very experienced, or perhaps both. And I would say probably I've dealt with most types of disputes between separating couples, although, as I like to say, as my team know, every day's a school day and there's always something else to learn. So today we're going to be looking at family mediation, its benefits, and really what it's all about. So from a mediator's perspective, I would say that it is a voluntary and confidential process. It allows parties to try and concentrate on the constructive and the positive if they can, and that can sometimes be very, very difficult. And they're able to do that with the mediator's help and guidance. The clients are in control of the process, it's their process, and it's the mediator's job to facilitate any discussions that they need to have between themselves. And it can be very difficult both for the mediator and for the clients, but it can be very worthwhile. It also allows the parties to prioritise the well-being of their children and actually their longer-term relationship as parents. It can be cost-effective and time-effective. Cost-effective, both in terms of financial cost and also the emotional cost to families, because as family professionals, we all know that separating and divorcing is a really emotional roller coaster ride for clients. So that's really my introduction about the basics of what mediation is all about. And I'll now pass back over to Sophie to start our question and answer session.
Great, thank you very much. Okay, so my first question for you then, Sue, is can you just, we'll start off easy, can you explain the difference between a MIAM and a mediation session?
Okay, well, both of them are part of the collective process of mediation. And the mediation process is a voluntary and confidential way, as I've said before, for parties to try and reach an agreement about differences that have arisen between them. So the MIAM is, in its full terminology, is a mediation, information and assessment meeting. So that's why it's called a MIAM, and is an initial session with the mediator. It is usually a one-to-one. There is provision for it to be a joint session, but I have never ever done a joint MIAM. it may be that other mediators in the audience have, and that would be interesting to hear about how they may work. I take it as the mediator's opportunity for me to meet the clients for the first time. It's an assessment meeting, so I therefore have to assess the matter, and I would say that it's not only just assessing the subject matter, but also assessing the client as to whether they're going to be able to cope with a mediation, and therefore in that assessment of both the client and the subject matter, my job as the mediator is to determine whether I think it's going to be suitable moving forwards for a mediation session. It's also actually an opportunity for each of the clients to decide if they want to go ahead with mediation on the basis of the information that's provided by the mediator, and actually, more to the point, if they feel that they can work with the mediator, because it is a very personal experience and something that they need to feel comfortable in doing. And so the relationship between the clients and the mediator is very, very important. So it's not just a one-way street. I think it's very much an assessment by both parties of each other to see whether mediation is going to work with those parties. It's actually quite disheartening when sometimes clients come to a MIAM just to get their certificate to go to court. So the tick box exercise, people. And this is usually on the basis because they don't actually understand what mediation is, or because they believe the other person won't come to mediation, or they just think that this is what they need to do because they need to go to court. And it really is my job as the mediator to assess and inform the clients about really what mediation is about, to allow them to understand whether it is the tick box exercise that they want to follow and just get their certificate, or whether they do actually want to give mediation a chance. The mediation session is where the mediator has assessed the matter as suitable and the parties have agreed to have the joint meeting with the mediator, and it will be in whatever format the mediator suggests. So co-mediation, where you work with a different mediator and you both run and facilitate the meeting. Same room mediation, where both parties are in the same room with the mediator or mediators. Or shuttle mediation, where there may be difficulties between the parties and the mediator views that perhaps it's better to keep the parties separate and for the mediator literally to shuttle between the two parties. So that's really the sort of types of meetings in a nutshell. And I know I haven't gone into the details of how each of the different types of mediation work or are set up, but that's it really in a nutshell. So Sophie, my question as a mediator is, do you think that as a solicitor, clients understand the difference? Do you think that solicitors understand the difference? And do you think it's the mediator's job to help with difficulties in those misunderstandings? Or do you think solicitors also have a role to play in that misunderstanding and helping clients understand?
So from my experience, a lot of my clients are unaware of a MIAM. So they don't realise that they will have an initial session, which is just a one-to-one between them and the mediator. The common perception of a mediation session is that they will be straight thrown in to a round table style meeting with what is often their former partner and the mediator. And I think once I've explained the process to them, that there is a MIAM and then a mediation session, they do feel a lot more comfortable that they can sit with the mediator, understand more about, what the process is, what's involved, and then they can have a full understanding before fully committing to that full mediation session. From my experience, solicitors do know the difference, and so they should. And this is mostly due to the family law rules and the requirement for parties to attend a MIAM before they make an application to court for child arrangement or financial remedy proceedings. I think that mediators could help, but this goes both ways with solicitors, just mediators and solicitors having a closer relationship. So both feel comfortable enough to ask questions when they have them. You know, like you said, every day's a learning day, not everyone knows everything. So it's good to build those relationships where you don't feel stupid asking those simple questions, and it just provides you with more information so you can pass those on to your clients.
Okay.
Yeah. So moving to our next question then. So what topics do you cover in mediation?
Okay, well, I would say in family mediation, almost anything, you know, can be discussed in the family arena, from simply who's going to divorce who, on what basis, and who's paying the cost, because that can sometimes be a, you know, a very, very difficult conversation for parties to have. You can have a discussion about how to fairly settle financial matters on a divorce or separation. And those again can be quite difficult conversations about how to split up assets, because sometimes it's not the financial value to people, it's the emotional value to people, and some things are more important to one person than another, so those can be quite difficult conversations. Parties can come to mediation before they even get married, or before they start living together, and they can look at putting together prenuptial agreements or cohabitation agreements. They can also discuss children's arrangements, and I think that's probably the most common understanding of what mediation's about. Excuse me, is about children's arrangements. And those can be from things like trying to agree a holiday for a child to go on holiday with a parent. The main one that people understand, which is agreeing arrangements for children, spending time with each parent, to even discussing a formal and permanent removal of a child or children with one party to another part of the world, so away from the jurisdiction of England and Wales. And financial matters for couples who aren't married are also able to be dealt with by family mediators, even though in the legal world they're not strictly family proceedings. As from a legal perspective, they fall into the category of civil proceedings, but because they concern a family relationship and a family breakdown, and often concern issues regarding children as well, it is something which a family mediator can cover in their practice if they feel comfortable in doing that. Sophie, as a solicitor, would you feel comfortable sending your clients to a mediator about any or all of those matters? Or do you believe that each case is perhaps different and really depends on the personalities of the clients? So is it the personalities of the clients that determine whether or not you think mediation would be a good fit? And do you feel that mediation is perhaps a harder sell to some clients as a process for agreement rather than other clients?
So I am a member of Resolution, First for Family Law. So being a member, this mediation is something that I do always recommend to my clients at the outset of the matter. So whether this is in our first interviews or during our initial correspondence, it's something I always give the information to my clients about, and just make sure that they are aware of it and that they know that this is an option that they can explore. In terms of when it is suitable, from my experience, when parties, you know, have views that are at the complete different ends of the spectrum, mediation may not be as likely to be successful. However, I have also had parties who have had views that are at the other end of the spectrum, gone to mediation, and at least that has allowed them to narrow down those issues. So it can be beneficial for all sorts of cases, and it very much depends on the individual facts of the case. And as we've previously said, it's a voluntary process, so both parties need to be happy to attend and comfortable to attend. I think that mediation is a harder sell to those clients who maybe feel hurt by a former partner, angry, or sometimes even afraid of that other party. And of course, in those cases, then mediation just would not be appropriate. So is mediation only for adults?
In short, yes, it is a process essentially for adults, because it's a process for adults to discuss their relationship breakdown, and really to find solutions to issues that are presenting themselves. But if one of those issues does relate to arrangements for children or of any sort, those children can have a voice in the process, and that would be through the involvement of what is known as a child specialist mediator. In order for such a specialist to become involved, both parents do have to formally agree to this happening. There is formal guidance by the Family Mediation Council, which is our overarching governing body, which suggests that only children over 10 should be involved in this way in the process. But as a child specialist mediator does have specialist training, children can be seen by the child specialist mediator, but that has to be subject to the expert assessment of the child specialist mediator in relation to that particular child or children. My view is that in order to separate the roles of the solicitor who is dealing with the parents in the mediation and the mediator who's actually going to be speaking to the children, I think that they should be done by two different people, because that allows the children to feel safe in expressing what they want to express to the mediator, safe in the knowledge that their confidences are going to be kept by that mediator, and that only what they want and agree with that mediator is fed back to their parents. And so often in situations where you have both parents who love their children dearly, as all parents do, and want the best for their children, they sometimes believe that the child is telling them that they want to live with them or don't want to see the other person, and often that's just a child very much in difficulties who's stuck between the parents who they love very much. And so it's really helpful having somebody that those children can speak to and can feed back into the mediation to allow the parents to make decisions being mindful of how the children are feeling. So with that in mind, I'm not actually a child specialist mediator, I have to say, and I'm more than happy to refer matters out to my colleagues who are child specialist mediators if the need arises. So, Sophie, do you think that your clients would find such a service helpful within the mediation setting?
I do think it would be suitable and useful for children who fully understand the process and want to be part of the decision making. And how successful this is completely depends on that child's understanding. This is less about the child's age and more about their maturity levels. I definitely think that it is the best course of action to have a separate and independent mediator for the child and the parents. From my experience, children often, they express their wishes directly to one parent and tell them what they want to hear. So it's very important that the child feels comfortable, that they're in a confidential situation where they know they can express their wishes and feelings freely. And it won't be passed straight back to their parents, which could potentially upset one of their parents if they're saying they want to live with one and not the other. So I think it's a difficult one. It definitely depends on that particular child, and I don't think, like I said, it could be pinpointed for, say, you know, children between this age and this age. It depends on that individual child and their maturity levels. So we are obviously in difficult times at the moment, and you won't be able to have your usual face-to-face appointments with clients. So how are you managing mediation remotely?
Well, I suppose you'd have to ask the clients that one. No, I'm offering mediation remotely because I'm working from home. And hands up, I'm going to say initially, I was absolutely terrified that I was going to cock the whole thing up and it would be absolutely terrible. But I suppose what we've got to realise is that everybody was learning about online working at the same time, and clients probably as nervous as as we were or are. And ultimately, when things go wrong, they're always resolvable. And you just have to kind of keep your patience and be, keep your sense of humour, I suppose. But like anything new, you do get used to it and you do get into your stride. And I have to say, I do feel far more confident than I did in the beginning. Clients seem to be okay with it, but again, sometimes there are difficulties with connections. They maybe don't have laptops and they're on phones. But really, my experience is we are working, pretty well, with the odd glitch that does still happen because we are dependent on technology and broadband and all those different things which are sometimes sent to as noise, I think. And also, some clients do actually feel more comfortable in their own space rather than having to come to an office, which is a more formal surrounding and perhaps feels less comfortable. And so that's its positives. I think because of the difficulties with everybody in lockdown and homeschooling and preschool children and all sorts of difficulties, it does entail sometimes clients having to keep children entertained elsewhere and often having to disappear off screen because there's some family emergency. But being patient and say keeping a sense of humor is often the way to deal with it. It is more difficult, and I'm sure maybe my fellow solicitors and fellow mediators would agree that it is more difficult to read body language when you're on a screen, because you're only seeing a tiny little bit of people, even less so when they're actually on a phone screen. And it is difficult to read body language, and it is much easier when you're face to face. And with the lockdown, clients can be distracted with other things going on at home, so they're laptop pinging, or they're getting an email, or they're getting a voicemail, and that can be controlled a bit more in a face-to-face environment. But we are where we are. We're in lockdown 3 at the moment, and for the moment it's the way I am dealing with matters. And even when we are back in the office, whenever that may be, I can see a place for this type of working with clients, albeit it may not be 100% of the time. But I still think that there is a place for remote working with clients, continuing for some time to come. So Sophie, as a solicitor, how do you feel about working remotely with clients, and do you feel that they're open to working this way? If you tell them that the mediator is working the mediation and dealing with mediation by video, do you get the impression that they're up for it, or do you get the impression that they'd rather not be doing it?
So I've had a great experience working remotely, and luckily my clients have been very understanding. Very few of them have requested a face-to-face appointment, if any, to be perfectly honest. They feel extremely comfortable working remotely. and I offer both telephone and Zoom calls. So we just do one or the other, and it seems to work really well. And of course, the courts at the moment majority of our hearings. So that's been a big learning curve, doing everything over the telephone or video. But again, it's just a new way of working. You learn it, and it has been working really well. It's just something else to get used to, isn't it?
Yeah.
So with mediation, when I have made a referral to mediation and explained it would be by video, a lot of the clients are content with this. The main concern that I've experienced with my clients is if they were to join a Zoom call and, you know, straight away be faced with their former partner, and this is daunting for them. So what I explained to them is that the mediator will have a waiting room in the Zoom call, and both parties won't be joined until the mediator is present. I think if the parties joined beforehand, it could potentially result in some awkward conversations, you know, scares the life out of them sometimes. So I usually just try and reassure them that measures can be put in place to prevent those.
Yeah. Okay.
So just touching on a similar sort of point then, what happens if the parties do not feel comfortable in close proximity with one another? Can mediation still take place?
It can. That's not to say it always can, but yes, it can if it's managed properly. And that would be where you would usually have a shuttle mediation, where the mediator literally goes between the parties, and the parties themselves don't see or speak to each other. So in a face-to-face, that's fairly easy to understand. You've got 3 rooms, you've got the one client in one room, another client in another room, and you've got a room for the mediator if they need it. Online, as you say, Sophie, that there is a waiting room, and also perhaps, as we maybe all or a lot of us know now, there are breakout rooms, there are breakout rooms on Teams and on Zoom. And whilst it was a bit nerve-wracking in the beginning, making sure that parties couldn't see or hear each other in breakout rooms, Richard, who's in our marketing team, will know that I was extremely paranoid that the parties would be able to hear the other person in the breakout room and hear the conversations that were going on. But he absolutely assured me that that wasn't the case. And as it turned out, it was absolutely fine. So it's assessed at the MIAM stage, and the mediator really has to determine at that point if there are issues that would prevent the mediation taking place remotely, or whether it should be a shuttle. And especially where the couple are still in the same house, it's absolutely vital for the mediator to determine whether mediation is suitable, even as a shuttle, where there is a risk that matters may boil over after the session when the mediator isn't around. So it's not just actually managing the issues in the room, it's also managing the potential issues that may arise after the mediation session or between mediation sessions, when the mediator is assessing the suitability for the mediation process. And it's an ongoing assessment. So it may be that the parties start off in the same room and then it becomes a shuttle mediation, or it starts off as a shuttle mediation and actually the parties feel able then to move into a same room situation. So it's an ongoing assessment by the mediator to ensure that the mediation is safe and productive for everyone involved in the mediation session. So as a solicitor, I know that there are solicitors, and I obviously I'm a solicitor as well, making referrals to mediation when there are concerns about domestic abuse can be a very difficult thing to do. So would you simply make a referral to mediation, Sophie, if there were concerns, or would you just simply ask the mediator to do the MIAM for a certificate? Do you think that solicitors need to explore issues with clients even in those situations? if they would want to try mediation if the mediator assessed it as being suitable, or do you think that that's actually the mediator's job for the mediator only to do that assessment as to suitability in situations where there may be abuse?
Definitely not. I don't think it should definitely just be down to a mediator at all. Whether I would consider mediation to be appropriate and whether I would recommend it to a client would again depend on the facts of the case and definitely the severity of any abuse that has happened in that relationship. As I did explain previously, I always give my clients the option to attend mediation and tell them about that option of dispute resolution, but explain to them that it is a voluntary process and one that they must feel comfortable with. I often find that clients find it daunting to be in front of what is often a former ex-partner who perhaps they've been hurt by or they just haven't seen in some time, and it can be a quite strange experience to think that they have to, you know, sit in a room with this person again and discuss all these things from the past. So usually in those sorts of cases, after they go away and have a think about it, and also some reassurance from me and telling them the different options that are available, they do come back and they do feel comfortable enough to attend mediation and think it will be useful. But where there has been domestic violence involved, obviously that's a completely different situation. Where there's been a kind of low level of abuse or maybe some emotional abuse, something like that, then I would tell my clients about shuttle mediation. And that this often relieves a lot of anxieties that they do have. Like I said, their fear is to sit in front of a room and in front of that person who they've previously had these experiences with, whereas if they can sit in a separate room and they don't have to look them in the eye, this can make them feel a lot more comfortable. Of course, where there's been a high level of abuse, mediation would not be something I would consider to be appropriate. This is first because I wouldn't want to put my clients in an intimidating situation. And also this would not potentially result in a fair agreement because one of them might feel like a more kind of dominant figure, and potentially you're not going to get what you want out of mediation, which is to have a fair discussion. So in those cases, it would often be that I would just recommend that my client attend a MIAM, get their mediation certificate, and then we can go from there. Okay, so just touching on that then, and kind of the high level of abuse cases and things like that, when would you consider mediation would not at all be appropriate?
I think that's very difficult to categorise as absolutes, because each situation is obviously very, very different and is part of the assessment at the MIAM. But in general, my view would be that mediation is likely not to be appropriate if there are issues with child abuse or in a financial case about money laundering. And those also have reporting conditions attached to them, which means that they can breach the confidentiality of the mediation. Mediators do have to report such things to the appropriate authorities, and also should be telling the clients in appropriate situations that they also should make the necessary reports. In terms of abuse of any type between a couple, that can be sometimes managed by a shuttle mediation, for example. And again, that would very much be subject to assessment at MIAM to explore it, to understand how the abuse happened. You know, for example, was it a one-off event when tempers blew over immediately at separation, something that didn't happen during the relationship, and something that hasn't happened since? That may be a situation which could be managed in mediation, probably initially by way of a shuttle mediation, really just to determine the temperature and make sure that actually the parties are able to deal with each other on an even keel, on an even setting, and that both have the same power within the mediation, because, as you say, Sophie, the intimidation or the power imbalance is just going to make mediation an awful process. It's just not going to work. And more to the point, it's not safe for the parties to be mediating in the face of abuse that means that there is a power imbalance or a financial imbalance in the relationship, because, as you say, you're never going to get to the point where potentially in a financial case reaching a fair financial settlement. So I think it's very much, I don't think there are hard and fast answers. I think it's very much a case of it's up to the mediator within the MIAM meeting to assess what the abuse is and how that might play out between the parties in a future mediation setting to determine whether or not mediation is going to be suitable in that particular case. So I think that would be all I would say in relation to that.
Great. Okay, well, thank you very much for that. We're just going to take a little break now, just to see if you have asked us any questions in the chat function. If not, then feel free to put any questions you have in there and we'll aim to answer them. We're just going to take a short 10-minute break for you to grab a cup of tea or a cup of coffee, and we'll aim to come back at 10:20.
We've had 4 questions, and I've drawn the short straw. I've been asked to answer 3. So Sophie's got the job of answering 1. So actually, really an interesting question, which I haven't been asked before, about the spelling of MIAM, and maybe I'm assuming that because I'm a solicitor and Sophie's a solicitor, that in the sort of professional industry of solicitors and mediators, that we all think that everybody understands what it is, and in fact it's an I, but it is an easy mistake to make, because it could quite easily be Y, but it is a mediation information and assessment meeting. We mediators do love our is it acronyms? MOU instead of Memorandum of Understanding. I think probably because a lot of things are a bit of a mouthful, we tend to just adopt the letters. So it's an MIAM. In relation to professionals being involved, absolutely they can be involved, whether it is a financial case or a children case, and we obviously touched upon the expert of the child specialist mediator in our earlier discussions, but you can also have in, for example, a child mediation where emotions are perhaps boiling over or running very high. You can have a therapist, or a counsellor, or a family consultant. A family consultant is something that in the family law scene, particularly among collaborative family lawyers, are a common sight, and they are people who come often from a therapeutic background, who have experience in dealing with couples in crisis, or dealing with children who are caught in the middle between their parents. And when you have a lot of emotions in the room in a mediation setting, having a family consultant or a therapist of some kind can be invaluable to help smooth matters and help clients concentrate on the way forward rather than looking behind them. In terms of a financial mediation, absolutely, I would say, as a mediator, and perhaps because I do a lot of financial work as a solicitor, having other professionals in the room, like pension experts, independent financial advisors, accountants, Any type of professional who is going to help the parties reach an agreement about the division of something, an asset, or the best way to divide it if it's a complicated asset, or indeed how to value something like a pension or some valuable asset that may have an intrinsic value that needs to be brought into the discussion, and it needs a professional to be involved. I would say in these days when we're working remotely, it's usually somebody who's joining in a Zoom call and is, you know, part of the process live in the session, or if it's something that needs a bit more in depth, certainly a letter of instruction, which would be really common to solicitors, can be sent out to an expert to advise within the process. So yes, definitely, I would say mediation is a multidisciplinary process, and where parties need other help, it's certainly welcomed, because it can only be for the good of the clients. The third, I'll then go on to number 4, which is what information can solicitors give to a mediator that would be really helpful and make the most of a mediation session. I think a solicitor's role really is to guide the clients who are coming into mediation to be as forward thinking as possible, and try and not look back to the difficulties that have caused the arguments, and trying to look for solutions rather than blame, and also to try and be as honest as possible. And even if that means saying, for example, as has happened, I don't want to share my pension with her, which isn't really a very helpful way of saying it, but if you're being honest, it's actually in a mediation session understanding what's important to the clients and actually working our way through those issues to see that even with those wishes, can they get to a settlement which maybe looks at everybody's wishes, or are they actually going to have to compromise and not actually both get what they want? So really just to be as positive as possible, as honest as possible, as open as possible, and as forward thinking as possible. And please, when they're asked to provide full and frank disclosure, to provide it. So I'll now pass on to Sophie to answer the other question.
Okay, yes, so I'm going to answer Emma Rigby's question in relation to the MIAM before you go to court. So this isn't for all cases. So for example, if there is a domestic violence application or something like that, it's not necessary for you to have to attend a MIAM. But in the family law rules, if you are making an application to court for a child arrangements application or to commence financial remedy proceedings, so to resolve the finances during divorce proceedings, then it is a requirement that you do attend a MIAM. And then your application must be made within 4 months after that MIAM session. So the only way you can kind of get around that is in urgent situations. So for example, if the child is at risk of, being abducted, to taken to another country or something like that, and, the court need to hear the case right away, then you can get an exemption from attending the MIAM. But if not, then the court will just basically not list the hearing at all, and ask you to attend the MIAM, provide your mediation certificate before they will list it. With the divorce...
Sorry, you were just about to tell me about the divorce. Yeah. What I want to know is what don't you have to have a mediation for? But you're just about to tell me. Sorry.
Yes, yeah. So with a divorce, you don't have to go to court. So it's basically a paper exercise, a divorce. So this is all done by an application which is sent to court. The parties don't attend kind of hearings and things unless the matter is contested. And the kind of court proceedings would only become involved when there is issues regarding the finances on divorce. So you can get divorced from start to finish if everything goes well, with parties not having to attend court once. There's no requirement for you to attend mediation or a MIAM or anything like that. So in terms of the kind of court requirements, it is fairly straightforward as long as both parties are in agreement and things like that.
Thanks very much.
So also if I can just add to that, although obviously I'm just going to adopt my solicitor hat for a tiny second, you only have to deal with finances and children by way of a MIAM if it's not a consent application. So if the parties agree, then you don't actually have to go to mediation at all. It's only if there is going to be a court application issue that the parties need to go for their MIAM to get their certificate. Okay.
Great. So if we can get back to our Q&A then. So where were we? Okay, Sue. So can solicitors attend mediation with their clients?
That's probably a question that fills my heart with dread. Yes, they can. I haven't done a mediation where it's happened. I certainly haven't been asked. I don't know how I would feel if I was asked, but that's probably because I haven't had any training on how to deal with that type of dynamic in the room, because additional parties will always change a dynamic. But I do know that over the last, I think, probably 18 months or so, maybe the last 2 or 3 years, there is training being offered by Resolution, which is one of the bodies involved in mediation and also family law, for something called hybrid mediation. And this way of mediating actively encourages solicitors to be involved. I'm not sure how many mediators are doing hybrid mediation or indeed have been trained. I really don't have any idea of the numbers. I haven't been for the training, although it's something that maybe something that I would like to look at. So really I would say the jury's out on whether I think it's a good or a bad thing. But like most matters, I think it very much depends on the personalities in the room. So the clients, the solicitors and the mediator, and their ability to have a good and productive relationship, because it's the mediation process and it's the client's process that the mediator is facilitating. And I would say that perhaps some solicitors may find that dynamic quite difficult to deal with. And I'm not actually sure whether the hybrid mediation training is actually designed for mediators or solicitors, or both in fact. And I think it would be helpful for both solicitors and mediators to have that type of training if that type of mediation is going to work for clients. So I suppose my question to you, Sophie, would then be, can you see yourself wishing to be involved in a mediation as a solicitor? And do you think it would be helpful? And indeed, if there was hybrid mediation training for solicitors, do you think that would be something that you would be interested in? Sorry, Val, if I'm putting you to expense there by asking her about if she wants some more training.
So in some cases, yes. I have had clients ask whether I can attend with them before, kind of informally. And this is mostly because they would just like the additional support and have someone, who's in their corner at mediation. But I haven't actually attended a mediation session with my client as of yet. With hybrid mediation becoming more popular, I definitely think this is the way forward, and it offers a more collaborative approach to resolving disputes. I particularly think this would be really helpful in financial remedy cases where solicitors can attend with their parties. Financial disclosure can be exchanged and analysed there and then. Negotiations can ensue and hopefully an agreement can be reached. This agreement can then be drawn up into a legal document and therefore the dispute is resolved. From my experience, when clients are getting frustrated and getting angry with the situation, it is because this dispute is dragging on and on and on. And they're thinking, you know, they can't see the light at the end of the tunnel. So I think with the hybrid mediation, if this would resolve in a quicker resolution, then of course this would mean happier clients, which is good for everybody.
Okay. A positive one for hybrid mediation then.
Yes, I think so. Do you think mediation is beneficial for solicitors?
Probably quite a tricky question, actually. What I would say is, as a solicitor, I know that a lot of children cases, the dispute isn't actually a legal dispute as such, and not one that a court wants to have listed. And there has in fact been recent judicial comment that basically the courts don't want these types of cases where they're having to decide, does mum pick Johnny up outside Tesco's or Waitrose, or is it 4 o'clock instead of 5 o'clock? Rather than an actual legal principle, what the parties are actually arguing about is the mechanics or practicalities of child arrangements. So they're in agreement that the child care should be shared and the children should be seeing both of them, but they just can't quite get to the point where they can agree whether it's 25 past or half past. So I would say that type of dispute, which as a solicitor I think can drive you a little bit crazy, is probably better as a mediation case rather than involving the solicitor, because what you've actually got is you've got two clients often in the room, rather than having the sort of round robin situation where you've got one client giving a solicitor instructions, then that solicitor goes to the other solicitor, then that solicitor goes to the, and sometimes it gets lost in translation and people get offended, and I can't believe you told your solicitor this. And I think if they're actually in the room and facing each other, those sorts of arguments can be resolved. And where there's not much money but a big difference of opinion, a lot of the narrowing of the issues between the parties can be done in a more cost-effective way. So how does that help solicitors? Well, it saves you from going mad with clients who are phoning you up about the 25 past, half past issue. And in both cases, both types of cases, I would say the solicitor still needs to be involved to advise really throughout the mediation and actually to draft up the documents, because solicitors are always needed for the documents and to keep their clients on track. And I suppose looking at it from a broader perspective, if you've got a happier client, then because the matter's tied up more quickly, you've got a solicitor who's tied up quickly and in a more cost-effective way for the client. A happy client means potential happy recommendations for the solicitor, and tying up matters more quickly for clients means more time for new cases for these solicitors. So I think all round, having happy clients can only be to the good for solicitors, and in fact all family professionals, because we need to be, client care is really the number one objective, or should be our number one objective. So I suppose from your side of the fence, Sophie, do you think it's beneficial for solicitors?
Personally, yes, but again, it completely depends on the case. From doing my work with the Family Mediation Council, it seems to be a common perception, and it would be interesting to get some views from solicitors that we've got on the call today, that mediators are kind of taking their work away from them, essentially. And you know, if parties go to mediation, this could have been a matter that could have been resolved by solicitor correspondence. And that is a common perception amongst solicitors, which unfortunately is a bit upsetting, and, you know, goes against what I was saying before, that I do think it's really important for solicitors and mediators to work closely together, as it can be great for clients. From my experience, my clients who have attended mediation tend to be a lot happier. It's taught them or retaught them how to communicate well with one another, which has then led them to reach an agreement between themselves, or reach an agreement with, you know, little solicitor input. But I do personally think it is very beneficial for solicitors, and I think it is disappointing if solicitors have that view that, you know, it's very commercial and business minded. I think both sectors can work well together.
Okay.
So just on that same sort of topic then, about kind of stealing solicitors' work, can a mediator draft legal documents?
Sophie, I think you're adding fuel to the fire. Yeah. So the answer is it's a very vexed question amongst the mediators groups. So I believe, and I'm sure somebody will correct me if I'm wrong, that basically this was a movement started by resolution, because a lot of resolutions mediators are also solicitors, and there has been some disquiet in the other groups of those mediators who are perhaps not lawyer mediators, and perhaps felt or feel that this is a line that shouldn't be crossed, or that it is giving lawyer mediators a better advantage in terms of the work that they can do. So it is something that we can do. I suppose the question then has to be, following from that, should we do it? And it comes down to the mediator believing that they have the appropriate skill to be able to draft the document that they are being asked to draft, and are instructed by both parties that they want the mediator to do it. Now, I have to say that I wouldn't do it where there were solicitors involved, because it just would not be appropriate. And in fact, it would probably be suicide as a mediator, because you'd never get any other referrals from solicitors again. So I think you've also got to be, as well as being client-minded, you've also got to be, realistic and be business-minded as well. And more often than not, I would say that it is the solicitor's job, and should be the solicitor's job, to draft legal documents that are, that arise after parties have been to mediation. That is the way it should be. However, I suppose the rider would be, if you have a self-referral to mediation, so that is where clients have come to you without being referred by a solicitor, and despite the best efforts of the mediator, they have steadfastly refused to go and get legal advice, and the other option is that they are going to end up doing it themselves. It can be done if it's if the mediator feels that it's appropriate, but again, there has to be another rider. The wording has to be as the clients wish it to be, and the mediator has the very difficult job of ensuring that there is no bias at all in the drafting. And that one, I wonder whether that is something that is possible to do. I don't know, because I've never done it. And perhaps it would depend on the document and the content of the document that I was being asked to draft, but it is quite a difficult concept to get your head round. And further, a mediator's job is also, even after they have drafted this document, to tell the clients that they have a cooling off period. usually about 2 to 3 weeks before they send the document to court, if that's what they need to do with the document. And really that during that cooling off period, they need to get advice on the document from a solicitor. So in short, can I do it? Yes. Would I do it? I think it would very much depend on the case and what I was being asked to draft. But I think the bottom line is, and my preferred option is, in most circumstances, solicitors should be the ones who do draft the documentation, because that is the right way to do it, and also to get advice on the document drafting. Sophie, as a solicitor, after putting fuel on the fire, what do you think about this?
I personally find it a bit concerning, and I would wonder whether a mediator could take a fully neutral view in order to be able to draft this document fairly. I think by drafting a legal document, the mediator is more likely to cross over that line into potentially giving the parties advice, or one party, or and I would also worry that, back to this kind of, more dominant stance, if one party feels that one of them is the better decision maker, or just has always made the decisions, or and it just might put the other person under pressure into thinking that they need to reach the agreement just so this legal document can be drawn up, and the matter is done and dusted. So I would worry quite a lot about that.
Mm-hmm.
I definitely like the idea of the cooling off period. I think that is essential. Like I said, that would then relieve that pressure, wouldn't it, to stop the parties feeling that they need to make the decision today, and it's all done and dusted, to give them some time to go away and think about it. But again, with mediators recommending parties to seek independent legal advice before submitting to court, great. But I also think, would parties be reluctant to do this if, for example, they've already paid some money for the mediator to draft that legal document? So I think there's lots of issues to think, and I guess I just haven't had experience of a mediator drafting a legal document, so it's not something I'm used to, which is why I find it a bit strange. Okay, so what happens if the dispute cannot be resolved?
Okay, well, back to an easy one. So if the dispute can't be resolved, then the mediator produces a mediation certificate, and that allows the parties to go to court if they wish to do so. And as Sophie said previously, the certificate is valid for a period of 4 months. Simply because it expires doesn't mean to say that they can then never go to court. They just have to get a new certificate, and that will often mean having to repay for another MIAM meeting. In terms of who gets the certificate, if only one person comes to a MIAM, then that person will get a certificate. If both parties separately come to their MIAMs, and the mediator at that point decides that it's not suitable for mediation, then each of them gets a certificate. That doesn't mean to say that both of them have to issue proceedings, because only one person can, but it gives the option to either party to actually issue proceedings. And if it's what's called an all issues type of mediation, where the parties are wishing to talk about children and financial matters, they will actually get 2 certificates. One for the financial proceedings and one for the children proceedings. And it may be that one of the parties wants to issue the financial proceedings and the other party wants to issue the children proceedings. So that gives them freedom of decision as to what they want to do and who wants to do it. And that would usually be in discussion with their solicitors. It's the same if the mediation starts, but for whatever reason doesn't continue, both of the parties will get their certificate or certificates. I do tell clients that simply having a certificate doesn't mean they have to issue proceedings, and that they do have 4 months to make that decision. And even if mediation, has broken down or isn't suitable, I will always encourage them to continue discussions through their solicitors, simply to see if matters can be agreed or narrowed, and really only then to go to court as a last resort if they really cannot resolve matters. So if I've given that message to a client, Sophie, and they were your client, do you find that when they have their certificates that they want to immediately go to court, or are they willing to discuss matters as mediation has been a bit of a catalyst to restart their communication with each other?
So a bit of both, really. I would say the majority do just want, once they've got a certificate, they want to go to court, but that has usually just been how my cases have played out. So, for example, we've started via solicitor correspondence to resolve the matter. This has unfortunately been unsuccessful. We've then attempted mediation, which has been unsuccessful. And then the clients feel as though, the last resort, the last resort is to make an application to court. But I've also had cases where mediation has been a gateway, like I said previously, to communication starting up again, which has been great for them, the parties, to understand one another again, and it's led them to being able to reach an agreement. But there's definitely both ways, but I would say the majority of my cases, it has been that once they have their certificate, they are keen to make that application.
Okay, so that really is our question and answer session finished. So I just need to check and see if we've got any more questions in the oh goodness me, in the okay, so quite a few, right, let me have a quick look. Okay, so first one from Julia. Has COVID-19 had an impact on the type of family issues you see in mediation and the quantity, or is it the same as previously? And do you think that some solicitors would try to advocate for their client or take over if they attended mediation? Okay, so the first bit, I would say the issues in terms of parties not agreeing about arrangements for children is the same as it ever was, but the basis of the difficulties has been COVID related issues where one party has decided that actually they're shielding when in fact they're not really shielding, and therefore the other party shouldn't see the child. So I think it's probably exacerbated the difficulties between warring parents, and I have seen situations where parties have actually managed to try and resolve things, and things are genuinely difficult because of illnesses, and they have managed to pull together and agree things in a really quite difficult circumstances. But there have been cases where people have used it to prevent contact, using the completely wrong word, saying contact, spending time with happening. But I think those were really in the first lockdown, when it was all new. I think people have kind of worked their way through things and are dealing with things a bit better. And I think people are realizing that actually not seeing the other parent isn't helpful. And also some parents are struggling with having to have the children with them all the time. And so in some ways, maybe COVID has made it a little bit easier. I just think it swings and roundabouts. I think that the difficulty really has been in relation to financial matters, given the uncertainty about the valuations. In terms of the hybrid mediation, yes, I think that there is a risk that solicitors would try to advocate for their client. I think Julia, from memory, from the little bit of training that I've done, the tiny bit of a snapshot of training, I think that it proceeds as a shuttle mediation. And so I think that the solicitors are to a certain extent there to assist their client, but I think the mediator has to be aware that there may be sort of some quite forceful personalities at work, and it may be that the mediator has to be a little bit more firm than otherwise. And that's really why I think having both the solicitors and the mediators doing training, I think is probably a good thing. Alice is asking, are solicitors using the CW5? Alice, I don't do legal aid mediation, so I'm not sure whether my colleagues who do legal aid mediation are using them, but certainly when in a previous practice, when I did have a mediation contract, I was using the CW5, and I think it's a very, very valuable form that allows those parties who are in a legally aided mediation to get some free legal advice from a solicitor to help them draw up agreements. Alice, have I got that right? Yes, she's nodding. So yes, a very useful form, the CW5. Okay. If hybrid mediation is completed and legal agreements are drawn up, would this then have to be processed within the courts? Yes, it would have to be processed through the courts. And I think the idea, Kelly, of the hybrid mediation is that because the solicitors are there, that the agreement is drawn up in formal terms. So heads of agreement or a consent order. And the idea is that that completed document is then sent into court. So I think the idea of the hybrid mediation is it is a complete process with the mediator and the clients and the solicitors all being involved to tie everything up. Now, the next one is from FR, who I think is probably Fiona Ryans, I'm not sure. Sophie, do you want to answer this one, or do you want me to do it because it's about collaborative?
I'll leave that one to you, I think.
How do I think hybrid mediation would differ from a collaborative case? You don't have to sign a participation agreement. You don't have to be a collaboratively trained lawyer. You could be just a family lawyer. And yes, the solicitors may take over. But I do agree with you, Fiona, that collaboratively trained solicitors may be helpful, or if they're non-collaborative trained solicitors, they might have a different approach. I think it's really a case of seeing how it develops. I think whilst collaborative, us collaborative trained lawyers do see the benefit in collaborative family law, unfortunately it doesn't seem to have taken off as a concept in a huge way, and it may be that hybrid mediation follows the same path, but you know, you never know, it may be something that is something that does take off and does help clients. I think it's a case of watching you know, how it develops, but certainly my view is, as a collaborative lawyer, that type of training would definitely help in a hybrid mediation situation if you were the lawyer involved, because you're less likely to actually want to try and take over the situation. Okay, let me see what Beth is saying. Beth says she doesn't feel it's taking work away. There will always be litigation heavy miles apart cases. Yes, I agree. And if certain matters can be dealt with amicably by a mediator, I would much rather see matters reached that way. Yes. And I agree that mediation does help co-parents communicate effectively. And once lawyers are done, and mediation is a better stepping stone for that. I do agree with that, Beth. However, mediation is a great process, but as we all know, there are collaborative and arbitration as well. But I definitely agree that in mediation, parties do learn how to communicate effectively, and they do need to do that as well. So I think that is all of our questions. So does anybody have any questions from the floor, or are you happy for us just to proceed? Silence.
We'll carry on. Okay, well, it's just 2 minutes to 11, so I just wanted to quickly touch on one resource that I want to make you aware of. So yesterday, the Family Mediation Council released a link to a YouTube video of a mock mediation session. I also sent this around in an email yesterday, and I've popped the link in the chat function as well in this call. And the resource is for use by professionals dealing with separated families, just to give them an insight into what happens during a mediation session. I personally have not had the chance to sit in on a mediation session, even though, you know, I've previously had mediators in firms I've worked at. But just, you know, calendars have not lined up, or clients haven't given their consent, so I haven't been able to sit in on one. So I did find this resource really helpful, and it was really interesting to see how the mediation session unfolded. So this will allow me to give my clients more information as to what they can expect from mediation in the future. So I hope you will find it helpful also. And just to finish off then, I'm not sure we have time to ask any more questions in regard to this, Sue, but just from a mediator's perspective, did you think it was a good representation of what a usual mediation session is like?
I haven't watched it the whole way through. I watched, I think, about the first 25 minutes. But what I did see, I thought was really, really good. I think it showed the mediation process in a really positive light. And I really felt that the mediator was really, really good in guiding the clients away from the negatives. So although she was listening to what they were saying, she was really good at guiding them and keeping the momentum going, and facilitating the discussions actually within the session, so that the discussions were actually between the two parties, and she was just interjecting to try and sort of nudge them along, and to nudge them into sort of a more forward-thinking way of dealing with matters. So I thought it was really, really good. I think it's a really helpful resource. And although Sophie, you said that, you know, it's for family professionals, I actually think that whilst it is quite a long session, I think if there are clients who really don't understand what mediation is about, and they want perhaps something a bit more than just us as solicitors saying, oh, you know, mediation is they can actually see it in action. And I think it would be a really good thing for them just to dip in maybe and get a bit of an idea, because as I say, it's a bit of a long haul. It's about an hour long, but certainly something that they can look at, and if they're interested, they can watch the whole thing. But I certainly think that, you know, whether it's professionals involved in you know, in the family professionals involved in the area, or clients, I think it's really a worthwhile resource to have and to view. Great.
Okay, well, thank you very much. So yes, please feel free to click that link in the chat just after this session. I am conscious that we are running a little over now, so I just want to thank you all for attending, and thank you, Sue, for being a brilliant co-host and answering all of our mediation questions. And we hope to see you all in a real coffee morning in the future. So thank you very much.
Okay, thank you everyone for attending, and thanks for listening to all of our question and answers, and hope that we answered your questions well enough that you asked. But if you want to ask any questions, feel free to contact either Sophie or I by email, and we'll hopefully be able to answer the questions that you have. Oh, okay, sorry. Oh, where's Joe? Oh, they're waving. Are they waving saying bye, or are they waving saying they want something to?
I think they're waving saying bye.
Okay, I shall end the meeting for everybody. Thanks once again for attending. Many thanks.